Shashi Kumar, and thank you, Shri Praveen, and the concerned citizens of India for this invitation. Ellarigu namaskara. Naan English al matadtini. I am here to share my thoughts with you today on the recent developments relating to the alleged remission of the convicts in the Bilkis Bano case. I say alleged because the order of remission, at least I have not seen, and I am unaware if it is available in the public domain. And when I see the order of the Supreme Court in 2022 directing the state of Gujarat to consider the representation of one of those convicts, I find a mention there to a petition filed under section 433 of the CRPC, which deals with the power of the government to commute a sentence, which is quite different from the power of remission under section 432. Be that as it may, I believe whether the order is one of remission, as is publicly perceived, or otherwise, the fact is that the 11 convicts in that case are today free. And we need to look at not just the legality of that order, and I will treat it as an order of remission for the sake of our discussion, not only at the legality of that order, but also at the justice and the morality issues that may arise alongside, as Dr. Shashi Kumar had spelled out. Let me first begin by saying that remission, the power of pardon, the power of commutation of sentences are actually to the credit of a criminal justice system. We do not belong to a hardline criminal justice system that believes in stoning people to death or amputations or other forms of eye for an eye. There is a degree of mercy that is built into our criminal system on the premise that there is scope for reformation, that the quality of justice, as Portia had said in The Merchant of Venice, is not strained, but I paraphrase, but drips from heaven like a gentle rain, that there is a quality of mercy that is built in to a criminal justice system, so that we're not vengeful in the manner in which we deal with those convicted of offenses, even if they be heinous offenses. And we have seen recently that, in fact, the convicts in the Rajiv Gandhi assassination case, one of them was granted release by an order of the Supreme Court in light of the fact that the governor of the state concerned had in fact not exercised his constitutional power. So be it under the constitutional framework, be it under the Code of Criminal Procedure, be it under the various orders that the state governments and the union government issue from time to time, the power of premature release of convicts, of remission, of commutation of sentence, and even pardon or mercy are very much part of our criminal justice system. And in fact, we ought to be proud of the fact that we have this layered provision in our law that recognizes the rights of the victims, the rights of society, and the rights of the accused, the convicts, and their families in different ways. I'm reminded of the scene from Shawshank Redemption when Morgan Freeman is finally let out after many attempts at being released from prison, and finally he finds himself so depressed out of jail that he says that one gets institutionalized when you're inside. And that is really not the purpose behind sentencing, that persons in jail become misfits to be released into society at some point in time. And if we look at the doctrine of remission in that background, I think in principle, I must say at the beginning, that the principle of remission is indeed one that is positive and welcome, with the caveat that that principle or that power of remission is exercised on the basis of criteria that are lawful, reasonable, and moral. Now, keeping that in mind, let us first look at the legality of this order of remission in this case. Just by looking at the legal requirements of a remission without going into more, there are many questions that arise. The first and foremost would be the question as to who the appropriate government is to have passed this order to begin with. Because this is a peculiar case where the offense was committed in Gujarat, but the trial and the sentencing took place in Maharashtra, as you're aware, on account of an order of transfer made by the Supreme Court of India, basis the circumstances that existed at that time. Now, under law, the order of remission, as I said, we're assuming it's an order of remission. The order can be made only by the appropriate government, which is defined as the government in the state where the sentence is passed, where the trial is conducted, where the conviction takes place. And in a sense, it is apparent that the state that would have the jurisdiction would be Maharashtra. But the matter does not end there. There is an order in 2022 of the Supreme Court, as I mentioned earlier, in a petition filed by one of the convicts challenging an order of the Gujarat High Court, where the High Court of Gujarat had rejected his petition simpliciter on the ground that the appropriate government is Maharashtra, and therefore the petition for grant of remittance of remission ought to have been made in Maharashtra. Now, interestingly, that was a 2019 order, but the petitioner concerned chose not to go to Maharashtra, but instead take his chance in the Supreme Court by challenging the order of the Gujarat High Court, resulting in the decision by which the High Court, by which the High Court's judgment was set aside, and the Supreme Court in fact found that the appropriate government in this case is the Gujarat government. And it said so basis the fact that the offense was committed in Gujarat. My research tells me that there are judgments to the contrary, which indicate that it is in fact the state where the conviction takes place that would have jurisdiction. But that question is settled by the judgment of the Supreme Court in this particular case, which refers to one of the convicts. So even if we park that question aside for a moment and assume that the Gujarat government was simply acting in terms of the directions of the Supreme Court, there are other requirements in the law that ought to have been followed. And I am unaware whether those requirements have been strictly followed. One is the requirement in the law to have a consultation or to seek the written opinion of the judge who passed the sentence. Now here I have seen Justice Salvi's comments in the public domain, and he was the judge who headed the special court which made the order of conviction, and I have seen him say that he was not consulted or his opinion was not sought in the matter. This, according to me, is a mandatory requirement. In fact, the full bench of the Bombay High Court has taken the view that the view of the judge concerned is binding on the government. The Supreme Court has not gone that far in certain cases, but has said that that opinion is certainly one of great value, that the government must consider the same in all seriousness. And even if the government feels that that opinion does not take into account the criteria relevant for the purpose of remission, it can send the file back to the judge concerned for reconsideration, something akin to the process of the collegium that we follow. And those criteria basis which the opinion of the judge concerned is to be made and basis which the government is to take a decision are well settled, where the gravity of the offense, the impact of the offense being individual or on society, the conduct of the accused, the propensity or the likelihood of the convict to be a threat to others if released or to replicate his conduct, the socio-economic circumstances of the family of the convict, etc., are all set in stone. And it's therefore not that remission is to be granted for the asking. Let's be clear that as much as I said that remission is a welcome part of our jurisprudence, it is not to be equated with an acquittal or a certificate of innocence. And in cases like this, where the convictions are rare and extremely hard fought, remission must be granted responsibly and keeping in mind the criteria that are laid down in the law. Now, apart from these criteria that I mentioned and the absence of the opinion of the judge concerned being sought, this is also a case where the union government ought to have been consulted. And that is because this was a CBI investigation. This was not a simpliciter state investigation where the jurisdiction begins and ends with the state government. I do not know whether that would have made any practical difference in this case. And I also do not know whether that consultation with the union government has indeed taken place or not, but by all accounts, it appears that it has not. And that becomes an additional legal lacuna in the order of remission that has been passed. I was interested to see what Justice Deepak Gupta, a retired judge of the Supreme Court, had to say in this matter. And he said the direction to consider the petition was in the case of one of the convicts. Perhaps based on the law laid down there, similar petitions were made by the others. But is it a coincidence that all 11 of them were found to meet all criteria required for remission? Is it that the conduct while in jail of all 11 was identical? That all of them were found fit to be released on the same day by the same order? I think that's a very important question also to be looked at. Apart from the procedural requirements of remission, the administrative law angles would also come in. And as Justice Salvi said publicly, considering the gravity of the offense, I need not repeat what Bilkis Bano and her family went through, those who survived it. I need not repeat that. I think that's fully known. It is inhuman and horrifying. And whether a case of this gravitas was fit enough for the grant of this merciful remission, I think is the elephant in the room, the question that we need to address. And please remember, today we know the identity of the victim. Ordinarily, in such cases, the identity of the victim is not known. The law maintains confidentiality. And perhaps in that sense, it may or may not affect our conscience as much. But this is a case where we know not just the identity of the victim, but we know the circumstances in which the offenses were committed, the time at which these offenses were committed. And I believe that all of those are central to us now moving on to the justice of the matter. Assume that the government concerned has ticked all the boxes and passed this order taking into account, I'm sorry, there's some disturbance behind me, taken into account, maybe I'll just pause for a second. Yeah. Taken into account all the criteria as also the seriousness of the offenses, I would be very curious to see how the order has been reasoned to justify the release of these convicts in this heinous case. I would believe one of the key criteria would be the remorse that the convicts show. In a given case, if a convict is genuinely contrite of the conduct attributed to him or her, and that is such that on a human element justifies release, I think we would be able to live with it. But I don't see any such remorse at all. The public images that we have seen are quite to the contrary. These gentlemen who have been released have been welcomed like heroes. The sort of welcome probably Neeraj Chopra received when he won his gold medal has now been given to them upon their release. And you have all seen that. Sweets, garlands, aartis, including women. I was surprised. Women welcoming them back to the fold. Now, that is the part I think that has jarred with everyone more than the question of the legality simpliciter. Is that the justice of the matter? Or is it, in a way, an affront to the system, a spite? Justice Salvi went so far as to say that it is bordering on contempt because it scandalizes the process of the court, having gone through a long-drawn trial, a hard-fought trial, confirmed up to the Supreme Court, to then welcome someone back into society as if they have done something of larger good. Is that not the irony? When the test is the impact of the offense on society, and we know how brutally impactful this offense is, the welcome given to them is as if social good has been done, as if to say they are social activists or reformers who have finally been granted the benefit of remission. And I think that is what remains with all of us. That is something the Supreme Court will consider in the petition that Mahua Mitra has filed, challenging this order of remission. I believe those would be the aspects from the legality as also the propriety perspective that the court would consider. And as Mahua Mitra said in an interview recently, let's decide whether Bilkis Bano is a woman or is she a Muslim. Because if we're speaking of the rights of women, as Dr. Shashi Kumar alluded to earlier, then I believe that is religion agnostic. It doesn't matter then. But that is also, unfortunately, something that is staring us in our faces in this case. And since I mentioned the remorse that ought to have been shown, I was reminded of the instance of a warlord from Liberia, whose name is Joshua Milton. And my friend Ryan Lobo, the photographer, has in fact done, I believe, a series on him. He was someone who was accused of having massacred up to 20,000 civilians. But he has now become an evangelist. And he goes from home to home of the families of the victims, seeking mercy and forgiveness, knowing fully well that it is at the risk of his own life. He could easily be done with in a sense of revenge. But he lives to tell this tale and has in fact become a great case study worldwide. If that is the remorse and forgiveness that one is showing, then I believe that the criteria of remission are met, subject to all of the other procedural requirements that the law requires. But that is clearly lacking here. And today we know the impact that this has had upon Bilkis Bano, upon her family, and I would like to say upon women in society, upon minorities, and I believe upon civil society at large. That's the reason we're having this conversation. You don't have this conversation on every case of remission. It's obviously pinched, not just pinched, but very seriously hurt the consciousness of certain segments of our society, which have driven us to have this conversation. And therefore, as I conclude, I want to say that this case cannot be seen in its isolation. It cannot be seen as a case of remission of 11 convicts in one case. It has far greater trappings and parameters to it. And why I say that is because it is making you and me and many others test the manner in which our criminal justice system is functioning. On the one hand, we hear of cases where grant of bail itself has become practically impossible. The grant of bail to Tista Settleward yesterday, interim bail, is being lauded and celebrated. some years ago, at least from my experience, that grant of bail was really no big deal, generally speaking. I don't think people had to struggle for bail the manner in which they do today. I may be wrong, but I'm speaking of perception, and perhaps you share that perception with me, that today the use and possibly the abuse of criminal law is being talked about a great deal more. So you have on the one case the use of criminal law to foist cases, to keep people in trial. And we've heard so often that the process is the punishment. It's not me saying this. Judges, retired judges, the Honorable Chief Justice of India, the former Chief Justice said so. These are responsible statements being made. So you have that paradigm where the application of criminal law is so sharp, especially with communities that are depressed or otherwise perceived to be fighting the good fight. And then you have cases where remission is granted, welcomed, and celebrated. And it's the same criminal justice system in play. It may be that in this case, the decision is of the government and not of the court. But that does not mean that this decision becomes simpliciter or executive or administrative in nature. It still has to be judicious, if not judicial. It still has to be just. And that is the reason it requires consultation with the judge concerned. That is why it requires criteria to be gone into. And this is where my concern is, friends, and I will conclude with this. I've taken a fair deal of time. I will conclude by saying that it is the same criminal justice system that we're looking at playing out differently. And that sometimes strikes at the heart of the rule of law. The rule of law in India, our constitutional morality, stands on that morality. It stands upon the spirit and the fairness with which it is applied. It is in that the faith is in the system. And if incidents such as this, such as the grant of remission, in contradistinction to other cases where criminal law is being used and abused, are seen, my serious concern is that faith in the system will continue to diminish. And we may then wonder why. Why is it today that you're seeing cases of lynching? Why are people celebrating encounters? I'm really surprised. I don't want to digress, but recently the encounter in Hyderabad, the other encounter we saw on the borders of Uttar Pradesh, they were celebrated as acts of bravery. And all of this tells me that there is a diminishing faith in the system, something that all of us must be concerned with, because all of this affects us directly. It affects us as a democracy and a responsible society. With these words, I thank CCI and Shri Praveen for this invitation, and I hand the proceedings back to Dr. Shashi. Thank you.
Thank you very much, sir. Thank you, sir. Sir, when we hear such serious words about law from you, person of your stature, it makes a deep impact, sir. You have made a wonderful basis, sir. The grounds for remission, you have made it amply clear on those points, quoting different judges. And the essential point is, ಸ್ನೇಹಿತರೆ ಇಲ್ಲಿ ನಂಗೆ ಹೈಲೈಟ್ ಮಾಡಬೇಕು ಅಂತ ಅನಿಸ್ತಾ ಇದ್ದದ್ದು ಪಶ್ಚಾತ್ತಾಪ. ಅಂದ್ರೆ ಯಾವ ಅಪರಾಧಿಗಳು ಅಪರಾಧ ಸಾಬೀತಾಗಿರುತ್ತೆ ಅವ್ರಲ್ಲಿ ಏನ್ ಪಶ್ಚಾತ್ತಾಪ ಮೂಡಬೇಕು, ಆ ಪಶ್ಚಾತ್ತಾಪದ ಲವಲೇಶವೂ ಇಲ್ಲದೆ ಇರತಕ್ಕಂಥ ಜನ, ಆ ಲವಲೇಶ ಇಲ್ಲದೆ ಇರೋ ಜೊತೆಗೆ ಬೇರೆಯವರಿಂದ ನಡೀತಕ್ಕಂಥ ಉತ್ಸವ ಸೆಲೆಬ್ರೇಷನ್ ಎಷ್ಟು ಮನಸ್ಸಿಗೆ ಘಾಸಿ ಆಗುತ್ತೆ ಅನ್ನೋದನ್ನ ಇಲ್ಲಿ ಶ್ರೀ ಸೋಂದಿ ಅವರು ಬಹಳ ಅದ್ಭುತವಾಗಿ ಇಲ್ಲಿ ಪ್ಲೇಸ್ ಮಾಡಿದ್ರು. ಅದು ನಮಗೆ ಐ ಥಿಂಕ್ ನಮ್ಮ ಮನಸ್ಸಿಗೆ ಅದು ನಾಟಬೇಕು ಅಂತ ಅನ್ಸುತ್ತೆ. ಯಾಕಂದ್ರೆ ಒಂದು ಸಮಾಜ ನೈತಿಕವಾಗಿ ಉನ್ನತ ಹಂತದಲ್ಲಿರುವಾಗ ಇಂಥ ಘಟನೆಗಳನ್ನ ನಾವು ಆಲೋಚನೆ ಮಾಡೋಕ್ಕೂ ಸಾಧ್ಯ ಇಲ್ಲ. ಆದ್ರೆ ವೆನ್ ದೇರ್ ಇಸ್ ಅ ಸೀರಿಯಸ್ ಮಾರಲ್ ಡಿಜನರೇಷನ್ ಇನ್ ಅವರ್ ಸೊಸೈಟಿ, ಐ ಥಿಂಕ್ ದಟ್ಸ್ ವೇರ್ these kind of celebrations or festival like situations occur. And hopefully our heldagene, hopefully Supreme Court will take all this into consideration while deciding upon those 6,000 signatories who have put up a petition before it to about this issue. Hopefully, we will get the right kind of reaction from the Supreme Court. Sir, thank you very much. And I heard that you have to leave the meeting. So before you leave the meeting, there is one question that is commonly heard. Because you have covered three major issues that have come up, where the state government has to take the concurrence of the central government, which is not done in this case. And then though it is a state subject, the central government guidelines are there on this issue. I have two questions here. One is whether the guidelines of the center are binding on the state governments, or is it advisory in nature? Second one is, if suppose the decision that is taken by the government in this case, like the rapists and murderers have been released, what will happen if the equal application law of this is demanded?
In fact, in this case, the first question really does not arise, because the direction issued by the Supreme Court in the case of the one convict who had approached the Supreme Court, the direction was clear that it would be the 1992 remission policy that would apply. And that was the policy applicable at the time. In fact, there can be some debate on that legally as to whether the policy of remission should be that when the offense was committed or when the right to claim remission arises, but there are judgments of the Supreme Court on that already. And therefore, that question, in a sense, is academic. There are, as you rightly say, now central government directions that have been issued to the state. And I would believe that the states would have to adhere to those directions while considering the question of remission. But your second question is more serious, which is, what is the effect of this if equal application is sought? Of course, look, this is not a judicial precedent that is binding, but on an Article 14 premise, though not strictly speaking, logically speaking or colloquially speaking, one can say if you can grant remission in this case, then why not in another? And that is where I said we cannot maintain a position that remission should be denied in heinous cases. No, that's not the law. But the bar, the benchmark has to be far higher, where the offense is serious, its impact on society, whether it is an offense qua minorities, qua women. Is it a POXO offense, for instance, qua children? Is it an offense under the SC/ST Act? Some of you must have seen that. The provisions of the SC/ST Act, Section 3, which disclose the very heinous forms of offenses that are perpetrated against our fellow citizens from the scheduled castes and scheduled tribes. I would believe that all of that needs to be borne in mind, and which is where, in a sharp case such as Bilkis Bano, perhaps one of the sharpest cases, and I would think one of the toughest cases to be granted remission, the order of the government has to be supremely well worded to make good many criteria as to why remission has been granted. And I would be curious whether the order meets that requirement. Otherwise, as you said, it may be legally difficult for others to say that you have granted remission here, please grant it to us. It doesn't work like that, because the considerations of each case are different. But that is again a possibility, and that is the colloquial or the logical question that arises. And therefore, when the appropriate government considers it, it should be thinking of this as well. What is the impact going to be of granting relief or remission in this case, qua other convicts who are undergoing sentences in your state, in your jails, for similar or less serious offenses? And therefore, that would certainly be a question that we all need to discuss. I have to seek your leave, as I said, because I have another function to attend. And thank you very much for that. Thank you.
Thank you very much, sir.